My name is Bernie Musring. I'm a solicitor specialising in litigation and construction, and joining me today is Kyman Mansfield, quite an esteemed colleague and good friend of mine, who specialises in
personal injury law. Well, I don't specialise. I don't think that I'm allowed to say that, but I'm a personal injury lawyer.
All right. Well, welcome everyone to the Caselaw Club. So, for today, we have for your pleasure the matter of Comcare and SDCS, a 2023 case of the Federal Court of Australia, case number 1509 of that year. Now, this case involved a claim for a psychological injury. The injured party, they were in 2016 working for the Department of Human Services as a customer service officer. And shortly after some incidents that occurred at work, they had to transfer to a different office in Queensland in 2017. Now, on the 22nd of November 2017, the respondent lodged a claim for compensation under the SRC Act for a psychological injury, which he described as anxiety and depression. And that was a medical assessment, and they had a slightly different description. But the applicant was an unrepresented applicant. So there are certain things which come forth in evidence and come forth in the facts of the case, which aren't necessarily directly represented in the submissions and the judgment itself. He alleged that this condition arose as a result of stress associated with his role in the self-service area. He alleged that it was also due to insufficient training and support, and there was a number of noted customer aggression incidents. However, early on in the judgment, the decision, thought it was interesting, the court stated that the respondent stated that he had first noticed the condition on 8th of August 2016 at 9 a.m., but he'd first sought medical treatment for the condition on 1st of August 2016, 1 week prior. So sometimes one of the advantages of having a team of lawyers looking after a case is that you have a very structured, very organized presentation of evidence and submissions. But you're a self-represented litigant, you don't necessarily have that.
And it comes with all of the baggage associated with being too emotionally invested in a case because it's yours and so on and so forth.
Absolutely. Now, that's a very charitable and fair assessment. But another assessment is that perhaps inconsistencies are already arising in the allegations. So how did he receive treatment before realizing the condition?
I think I personally think that there's a case to be made. You receive treatment before even realizing that that there is something actionable. You especially in the realm of psychological injury, where you don't know you're broken until you actually are really, really broken. You'll see symptoms start to arise, but it doesn't become a recognized psychiatric injury until a certain threshold is kind of crossed.
Yeah. The court taught us about that. Well, all right, let's roll forward. So 2017, the application is made. 22nd January 2018, Comcare determined to reject the respondent's claim. And the court described a later affirmation of that decision, said the original decision was made, and then an employee of Comcare affirmed the decision. And in that, the court describes their response, including, quote, at paragraph 5 of the decision, Comcare accepted that the respondent suffered from an injury, namely adjustment disorder, with mixed anxiety and depressed mood. Here, we're identifying the precise disorder that I was talking about earlier. However, the litigant hasn't described it in this way. Adjustment disorder with mixed anxiety and depressed mood, which was likely to have contributed to a significant degree by his employment with the department. Although Comcare appeared to accept the injury had occurred in or after July 2017, it rejected the assertion that the injury occurred in 2016 on the basis that there was insufficient evidence. It's a key thing, key foreshadowing, let's call it. It therefore determined that the injury was excluded from the compensation as a result from various reasonable administrative actions taken between July and November 2017. So administrative actions basically being actions taken by his employer against him. That's my reading.
Right. That's quite interesting, actually. Not knowing the full scope of the of this particular claim at the moment, but in New South Wales workers' compensation, there is actually a defence for psychological injuries, where that injury arises wholly or predominantly by, and the section we deal with it a lot. I can quote it almost verbatim. The injury arises from the quote reasonable actions of the employer with respect to performance appraisal, including hiring, firing, promotion, and demotion of the employee.
So this would be section 5, subsection 2.
So in the Workers' Compensation Act, section 11, capital A.
Oh, okay.
But it probably has a similar ancillary in the Comcare Act.
Let's see. Definition of injury, 5A. In this act, injury means A, a disease suffered by an employee, or B, an injury other than a disease. Let's skip forward a little bit. But does not include a disease, injury, or aggravation suffered as a result of reasonable administrative action taken in a reasonable manner in respect of the employee's employment.
So it's
pretty damn close.
It's considerably more broad, I interpret, than the New South Wales ancillary, but I think it hits the same. It hit
reasonable administrative action taken in respect of is broader.
In respect of the employment, so it's not just in respect of performance.
Yeah, so it's reasonable administrative action. I'm interpreting that to be anything from a reprimand to
a warning, a reprimand, a
here's your job, here's how to do it.
Yeah, directions, performance improvement plans, likely.
They accept that a work injury has occurred, psychological injury, resulting in this condition, but they say that it's occurred later. They say that it's occurred as a result of reprimands or whatever administrative action has occurred, that we don't know exactly what's occurred. And they say, as a result, no, you're not going to get compensation out of it. So then the respondent brought an application to the tribunal. This is the Commonwealth Tribunal. They appeal the determination, and the result of that is that there's a decision by the tribunal. This is the subject of the review. There's a decision by the tribunal that the symptoms onset has occurred in August of 2016. Before the administrative action, and therefore by implication, my reading the judgment was that by implication it was therefore caused by administrative action which occurred later. It could not have been caused by that.
Yeah, if they accept that it arose in August 2016.
Precisely.
And the reasonable administrative action occurs in 2017.
Right. Yeah. So then it's actually Comcare that brings this particular appeal.
That's right, and that's why the claimant in the matter was referred to earlier as the respondent.
Exactly.
Yeah.
Yeah. So it comes to appeal, and there's 4 grounds raised by Comcare. However, they only found it necessary to answer 2 of those grounds. We'll go through them. They referred to them at paragraph 14 of the decision. Quote, Comcare relied on 4 related grounds of appeal as follows. In finding this is the first one, in finding that the respondent, here we're referring to the person who was injured, experienced a symptom onset in August 2016, the tribunal necessarily found that the respondent had suffered an injury within the meaning of section 14 of the Act at that time. That finding was 1, not supported by relative probative evidence. 2, it's not to address the elements of section 14, more particularly whether any injury so caused results in incapacity for work impairment. And they're referring here to the Act, I believe, the elements of section 14. So they're referring directly to the elements of section 14. Incapacity for work or impairment. And 3, do not identify any incidents of the respondent's employment which were causative of the injury in August 2016.
Right. So
that's all the first ground of appeal.
Yeah.
And the second ground of appeal is that the finding that there was no evidence of the respondent's injury in August 2016 was a result of reasonable counselling action, whether formal or informal. So the respondent received counselling, treatment.
Right.
Sorry, I think this is referring to that they did receive counselling. They received medical counselling in 2016 when they realised they had this condition.
Yeah.
And they also received but I believe my reading of it is that this is referring to the counselling they received in the course of their employment. This may be the administrative action they're referring to.
Right.
So the finding that there was no evidence of the respondent's injury in August 2016 was a result of the reasonable counselling action, whether formal or informal, taken in respect of the respondent's employment. So they were counselled as to the respondent's employment. Was not supported by probative evidence. There was no probative evidence as to this. More particularly, the tribal tribunal's reasons do not refer to any evidence to support this finding, and that there was ample evidence that such informal counselling was taking place in August of 2016. So those are the two grounds that they've addressed. There was, as you know, you foreshadowed correctly, there was additional two grounds of appeal that there was a procedural fairness issue.
I think the brass tacks of it, though, is that they had they'd found substantive enough reason to accept a referral from Comcare to the court, and so they didn't have to deal with with points 3 and 4 because they'd already found an issue with points 1 and 2.
Yeah, but interestingly, they didn't particularly suggest. Well, I'll get to that at the end. They didn't direct them to make a finding; they remitted it.
Right.
All right. So back to these grounds. The court outlined the position of the law regarding the thresholds for a tribunal decision. So they said, in order for it to be appealed, we need this. Paragraphs 32 to 34 discuss it. The fact that the tribunal is not bound by the rules of evidence does not enable the tribunal to make a decision upon evidence which lacks rational probative force. I found this was really interesting.
Yeah.
So they cite a plethora of decisions. And then paragraph 33, in support of its first ground of appeal, Comcare placed particular reliance on the decision of Keifel J in Rodriguez. In that case, Keifel J was faced with an appeal from a decision by the tribunal in relation to a compensation claim, where the tribunal had based a finding in the length of an incapacity period on its own view of the evidence and not
in accordance with the medical opinions put into evidence.
Exactly. So Her Honours held that if a view is formed by a tribunal which goes beyond the opinions expressed by the experts in evidence, is a key point, beyond the opinions expressed by experts in evidence, fairness requires that it be disclosed and the parties permitted an opportunity to address it.
Yeah, absolutely.
Her Honour found that it was not open for the tribunal to draw its own inferences and went on to say in paragraph 26, in an area which required an understanding of a disorder, the tribunal could only receive the opinions, have the basis for them explained if they differed, and apply logic to determine which were to be accepted. The upshot of this decision, as confirmed by the full court in Comcare and Wuth, is that legal error may be found if the tribunal bases a conclusion upon its own views and circumstances where the matter required expert evidence, and medical findings around the onset of a medical condition are likely to be something which require medical evidence. Now, that's my own addition at the end of the quote, though. It's likely to be the case, medical conditions. Ultimately, the court found that the tribunal had not satisfied the threshold. They laid out the insufficiencies. So Comcare did not at any stage accept that the respondent's adjustment disorder was suffered on the estimated nominated date of the injury of 8th of August 2016. Indeed, the tribunal identified the parties' competing positions regarding the date of injury in a preceding paragraph. Putting that aside, the tribunal did not engage with any of the submissions or evidence it recited. The tribunal has not explained what evidence it accepted or given weight, and the reasons do not evidence an undertaking of the statutory task as set out in May of giving consideration to the precise evidence, fact by fact basis accepted on trial. I found this was really interesting because they have to consider the evidence, and it seems like the court is going further because here we have a self-represented litigant who's making allegations about the precipitation of their own medical disorder.
Yeah.
At this date, I started to experience these symptoms. So it's very much they're stating their own situation has arisen at this point.
Yeah. Yeah.
And it's at a later point that it becomes exacerbated and they cease to be able to work. And the other side has tendered medical. There's various affidavits, and well, I mean, it's sort of not clear to me how much of it is medical and how much of it is. This is the earlier confusion that I had around whether the counselling referred to as their medical counselling. They're being counselled as to dealing with these issues on a personal counselling, psychology counselling, or counselling as counselling in respect of their job. They're being counselled how to attend to a particular function of their job.
I interpreted it as counselling in the function of their job rather than medical counselling.
I think it was.
Yeah.
I think it was too.
Yeah. But it is really interesting, actually, that the issue of the onset of symptoms being effectively substantiated by expert medical evidence or alternatively medical evidence, and then the tribunal, the court seems to assert that the tribunal had made its own findings, and just thinking about it rationally, that the reason why we obtain expert medical evidence, especially when it comes to questions of mechanism of injury and onset of symptoms, is because generally speaking, the expert medical professional is and the reason why they are an expert is because they are in a position to be able to obtain cogent instructions from the claimant or the injured worker, and also test that evidence with the injured worker and put things to them and tease out information that may not be readily apparent. And that is the distinction between an expert and a layperson in being able to be able to really substantiate that evidence as being an expert opinion as opposed to a mere opinion or a lay opinion.
Yeah. I see what you're saying.
Yeah.
It's the difference between someone, say, pointing out that a person who is consulting with a psychologist is reporting to the psychologist their symptoms, and then the psychologist saying, okay, they've experienced these symptoms at this point in time, where the psychologist is in a position to understand and to check and to test that evidence and to assess the person independently.
Yeah. And it's important to remember that a diagnosis is a cluster of symptoms that are then described using language, rather than the other way around, where the language where the
informs the
language informs the cluster of symptoms. Yeah. And so the reason why we provide expert opinion is because they can provide a diagnosis. And they can also engage with the medical material and suggest things such as the onset of symptoms. And it may very well be the case that even the claimant doesn't actually know when the onset of symptoms came on, because they don't know what to look for, because they don't have the required medical training. And so they may be saying, oh, I started to feel this way then. And the doctor can go further into it and ask them other questions or probe further into their mental state to notice that actually different symptoms which are symptomatic of a certain diagnosis actually started to appear on a different date than the claimant was initially trying to assert. Ultimately, the respondent saying that they first noticed symptoms is an opinion as to what they think the symptoms of a certain psychological disease or disorder are. So it is a lay opinion that they think that these symptoms, they think that these are symptoms because it's how they feel and it's how they communicate how they feel. But two, that those symptoms arose at a certain time and date.
That's really interesting, because that sort of gives almost a new meaning to the first sentence, one of the first sentences we discussed, which is the court's acknowledgement at section paragraph 3 that they referred to. So that makes me think that perhaps the respondent was remembering that the respondent is noticing that the first symptoms occurred at a particular date, but they're noticing at this point in time that that's when they first occurred.
Yeah.
Look at this. Look at this. So the respondent stated that he first noticed the condition on 8th August 2016.
Yes.
Is it that he first noticed that he was feeling depression on 8th of August 2016?
Well, it could very well be the case that the respondent first recognized what he, in his opinion, knows are symptoms of depression on the 8th of August.
Or now he's recognizing now that the first instant he felt that symptom being depression,
as in
was
in a
at.
post factum. So
Yeah.
reporting on it later, he misremembers the date, or he says correctly, I first noticed these symptoms on the 8th.
Or he's suggesting that the symptom first occurred after he started seeing the symptom being different from his reason to see the psychologist. I mean, depression might be different from mixed anxiety and depressed mood. Adjustment disorder might be different from depression.
Well, ultimately, all of these diagnoses conform to they conform to a set of criteria that have to be met, and it's up to a sufficiently qualified medical expert to make a diagnosis based on objectively analyzing or objectively assessing the injured worker and identifying that injured worker meets those criteria.
Yeah.
And then there's they apply levels of discernment and discrimination to make sure that they're not making a diagnosis for something else. And then they provide or they proffer a suitable diagnosis.
There was affidavit evidence tendered in support of this, so in support of the condition.
Right.
But my understanding is that the litigant himself is the one who was given the specificity around the dates.
Right.
So the tribunal has favoured the specificity around the dates and then ostensibly based a substantial amount of their reasoning around that.
Yeah.
Where the error flows from.
Yeah.
But it's still, I think that's perhaps a better way, because it's a little bit more charitable way, but it actually might come out to be a bit of a fairer way of considering it, because there's some perhaps nuance around those words that might encourage other descriptions than the potential, than promoting the potential interpretation that there's a discrepancy in what is described.
Yeah. That
I've pointed out, because my first reading was that the fact that treatment was sought before the first symptom was realized is a discrepancy, which might then lend to a decision that this is not the order of events that has occurred.
Right.
Anyway, all right, so the court considers the grounds. I might continue at paragraph 53, which is where I believe we're up to. The reasons did not identify that any of the other above the legal principles were applicable in its assessment, so it didn't identify the legal principles of whether the respondent had proven he suffered from a disease in August 2016, nor was the tribunal's reasoning consistent with those legal principles. Paragraph 54. Critically, the tribunal did not have regard to the fact that subjectively experienced symptoms without an accompanying psychological or psychiatric charge are insufficient.
Sorry, it's physiological, not psychological.
Yes. Sorry, you're right. Without an accompanying physiological or psychiatric charge are insufficient to found an injury or disease under the SRC. So it's about the definition of it being achieved. And as you said, most circumstances it'll arise out of whether a criterion are met, and that needs to be assessed by a medical expert, by a person who's
sufficiently qualified to provide an expert opinion or at least a diagnosis.
Yeah. So the court clarified the reasoning. Paragraph 69, it said that if, contrary to the conclusion reached above, it could be said that the tribunal's finding that the injury occurred as early as 2016 was not affected by error, the finding which follows also warrants consideration. Now, the court also said that they're not saying, and I'm paraphrasing very, very broadly here, but they're not telling the tribunal that because there was a flawed logic in their reasoning, the reasoning should be decided differently. They're leaving ground for the tribunal to make a decision which ultimately comes to the same conclusion, which is no, that this was founded. The tribunal needs to come to that conclusion again, if that's the conclusion they're going to come to. So ultimately, I'm not aware of exactly what the outcome of this case is.
It may still very well be going on.
It's possible.
If this is a 2023 case.
Yeah.
Yeah.
In the federal court. It's also possible that it may have settled.
Yeah.
It's not clear. But in any case, it's fascinating. We're getting an inside look at,
Yeah, yeah.
the grounds for appeal and what to look for.
It is it is absolutely very fascinating. I think it highlights the importance of just having, proper preparation for a claim, and sometimes getting timely and good legal advice about how to proceed with a claim early on can be the difference between success and ending up having your matter appealed to the federal court.
Yeah. Oof.
And also the advice that I always give to clients is that you have to have an ongoing and open and frank and honest dialogue with all of your treatment team, especially with your GP and your psychologist, because one, they're the people that you need to tell your symptoms to, and two, they're the people that can give you medical advice.
Yeah.
And so it generally speaking, it's very important that you make sure that you're being honest and open with those people. And then because that all evidence is good evidence, except the evidence that's bad. But it all has it all may have the propensity to contribute to the claim in a certain way. And at the end of the day, the people that are in the best position to know how you feel yourself, and the way that you express that to other people is by expressing that to other people and not sitting in silence, not suffering alone.
Yeah.
And also, being proactive about your problems that you're having with injuries and so on and so forth.
I think the other thing is that often experts can tell when a client is attempting to put their finger on the scale a little bit.
Yeah. And that's why I always give them the advice that they have to be honest. You're never going to be able to argue black is white. And you're right. Experts they deal with a lot of people that there is a broad range of study into malingering, and people that they not necessarily make up symptoms, but that they think that they are more affected by a psychological injury or by an injury generally than they actually are. And it's a fascinating area of medicine that I don't know too much about because I don't study medicine.
Yeah.
But it is very, very common, and these experts, when you brief experts for diagnostic reports and so on and so forth, they are very adept at identifying people who may be malingering or people who may be putting on symptoms.
Yeah.
And there's also lots and lots of ways that they can test their diagnoses. From the moment that you step into their medical consulting rooms and they're watching you on CCTV, to when they watch you walk out into the car park, there's ways for them to be able to tell. And in different jurisdictions, there are different different rules regarding the conduct of the insurer. And for example, in motor vehicle accident claims, it's very common that the CTP insurer in New South Wales may organise for a private investigator to observe your whereabouts in public locations from time to time to try and gather evidence that the injuries that you are suggesting you have are not as bad as they may as you actually may be asserting them to be.
The good old TV case of so and so with a broken leg who shows up on camera on the news beating someone up with
doing a cartwheel.
Yeah. With a space boot, rip it off.
Yeah.
I think that's in some show or something.
Yeah. Obviously there's laws about adducing that evidence, but you see it all the time. CTP insurers, workers' compensation insurers, adducing surveillance footage of claimants to suggest that the claimant's injuries are not necessarily manufactured, but
they're not what they're being made out.
Exaggerated to the medical assessors. And so they are very, very good at their jobs, and they are very good at working out who is and who isn't making things up.
I think also in the scope of things, probably trying to mislead a psychologist is not one of your best areas. I mean, I've seen how courts tease out if an expert's not aware, if an expert's not sure, putting him in front of a judge and trying to get them to say something, or having them promote an idea that they're not sure of is poor idea.
Yeah, but no, absolutely. Ultimately, the court and the commission are protected by requirements under the Uniform Civil Procedure Rules, and in New South Wales, we have the Personal Injury Commission PIC directions. Which PIC directions. PIC Personal Injury Commission directions.
All right. Thanks for tuning in to the Case Law Club.